inform that Article 165 confers this court with the jurisdiction to determine whether any law is inconsistent with or in contravention of the Constitution. The question whether anything said to be done under the authority of the Constitution is inconsistent with the Constitution. We've quoted those paragraphs. Now, in connection with the doctrine of avoidance, we referred to Communications Commission of Kenya, and we've quoted also from that decision that the principle of avoidance entails that a court will not determine a constitutional issue when the matter may properly be decided on another basis. The Supreme Court relied on a South African decision, and we've basically quoted from the decision of the Supreme Court, paragraphs 256 and 257. The court had the following to say, and we quoted from it. In summation, the doctrines of ripeness and constitutional avoidance shun to deal with a constitutional issue where there exists another legal cause which can give the litigant the reliefs he seeks. Crucial. Having acknowledged that the predominant issue is whether the provisions of the Affordable Housing Act are in conflict with the Constitution, it is our considered view that that doctrine of avoidance is inapplicable to the petitions as consolidated. I'll invite my colleagues to consider to read our judgment on the second issue, and that is whether the Act is constitutional or not, and they'll share that both Justice Mungare and Justice Chigiti.
Having disposed of the technical points, we now turn our attention to the merits of the petitions. The brief background is that by a judgment of this court, are differently constituted, various provisions of the Finance Act 2023 were declared unconstitutional. One of the nullified provisions was Section 84 of the Act, which sought to amend the Employment Act in the following terms. And I quote Section 84 of the said Act. The Employment Act 2007 is amended by inserting the following new sections immediately after Section 31A. Insertion of new section of number 11 of 2007, Affordable Housing Levy, that 1B, notwithstanding the provisions of Section 32A, B, C, and D of the Act, each employee and employer shall pay a monthly levy to be known as the Affordable Housing Levy. 2. The purpose of the Affordable Housing Levy shall be to provide funds for the development of affordable housing and associated social and physical infrastructure, as well as the provisions of affordable home financing to Kenyans. 3. The Affordable Housing Levy shall not be used for any other purpose other than development of affordable housing and associated social and physical infrastructure, as well as the provisions of the affordable home financing to Kenyans. 4. The monthly levy payable by the shall be A. 1.5% employee's gross salary for the employee, and 1.5% of the employees monthly gross salary for the employer. In the judgment aforementioned, the court expressed the view that Section 84 proposed to introduce a new levy known as the Affordable Housing Levy without a proper statutory framework to govern the imposition and administration of the levy. Accordingly, the court held that the provision was in conflict with Article 210 of the Constitution. The provision was therefore declared unconstitutional. However, the court granted stay pending the enactment of a substantive legal framework. It accordingly ordered as follows: that the introduction of the levy through amendment of the Employment Act by Section 84 of the Finance Act 2023 lacks a comprehensive legal framework in violation of Articles 10, 201, 206, and 210 of the Constitution. The imposition of the act against persons in formal employment, the exclusion of non-formal income earners to support the national housing policy is without justification, is unfair, discriminatory, irrational, and arbitrary, and in violation of Articles 27 and 201 of the Constitution. The fourth respondent proceeded with speed and published the Affordable Housing Bill, number 75, by Kenya Gazette Supplement number 236 of 4th December 2023. It was processed and passed on the 21st February. The bill was thereafter of 2024. The bill was thereafter forwarded to the Senate on 12th March 2024, and upon being passed was given presidential assent on the 19th of March 2024. Sections 4 and 5 of the Act became operational immediately by dint of Section 1A of the Act. It was on the same date that the President appointed the chairman of the board. The rest of the provisions were operationalized on 22nd March 2024 by a special issue of the Kenya Gazette Supplement number 70 of 21st March 2024 through Legal Gazette number 54. The court takes judicial notice pursuant to Section 85 of the Evidence Act that following the operationalization of the Affordable Housing Act, the respondents proceeded to implement the Act by Gazette Notice number 4350, 4351, and 4351 of 12th April, and Gazette number 4495 of 17th April 2024, where the CS Lands appointed members of the board. It was the operationalization of the Act that precipitated the filing of the petitions. It is trite that statutes enjoy the presumption of constitutionality, and thus the onus was on the petitioners to establish that the impugned act is indeed unconstitutional as alleged. We bear in mind that the burden of proof is on the petitioners to prove all the aspects of their petitions to the requisite standard. The Supreme Court, in the case of Samson Guel and 5 others, versus Kenya Medical Research Institute and 3 others, stated as follows, and we quote from paragraph 47 of that judgment. It says, "It is a timeless rule of the common law tradition, Kenya's juristic heritage, and one of fair and pragmatic conception that the party making an averment in validation of a claim is always the one to establish the plain veracity of the claim. In civil claims, the standard of proof is the balance of probability. Balance of probability is a concept deeply linked to the perceptible fact scenario, so there has to be evidence on the basis of which the court can determine that it was more probable than not that the respondent bore responsibility in whole or in part." This position was reiterated by the Supreme Court in Wamwere and others versus the Attorney General, and we have cited the holding of the Supreme Court, which said a petitioner bore the burden to prove his or her claim of the alleged threat or the violation of the rights and freedoms of the requisite standard, which was on a balance of probabilities. Such claims were by nature civil causes. The onus of proof was on the first appellant to adduce the sufficient evidence to demonstrate that she owned or erected or lived in the alleged properties, and that state agents interfered or deprived her of the subject properties. That was the import of Section 107 of the Evidence Act on the burden of proof. End of quote. We further cite the decision in the Council of County Governors versus the Attorney General by the mastivo judge, as he then was, and I will not read that, but we have lifted a bit of the ruling on the general presumption that every act of parliament is constitutional and the burden of proof lies on every person who alleges otherwise. Further, in the East African Court of Appeal, in the case of Danambo versus the AG, the court held that the Constitution is a living instrument, having a soul and a consciousness of its own. Courts must endeavor to avoid crippling it by construing it technically or in a narrow spirit. It must be construed in tune with the lofty purpose for which its makers framed it. Fundamental rights have to be interpreted in a broad and liberal manner, ensuring that our people enjoy their rights. Our young democracy not only functions but grows, and the will and dominant aspiration of the people prevail. End of quotes. The guiding principle in determining whether the sections of an act of parliament are constitutional were laid out in the case of Institute for Social Accountability and another versus the National Assembly, where a three-bench of this court held as follows. First, that this court is enjoined under Article 259 of the Constitution to interpret the Constitution in a matter that promotes its purpose, values, principles, and advances rule of law, human rights, and fundamental freedoms in the Bill of Rights, and that contributes to good governance. In exercising its judicial authority, this court is obliged under Article 159 of the Constitution to protect, promote the purpose and principles of the Constitution. Additionally, we also looked at the petition of number 150 of 2016, which was consolidated with petition number 234 of 2016, Attorney General, EG and others versus Attorney General, where the three-bench judge held that the technique of paying attention to context in statutory construction is now required by the Constitution. As pointed out earlier, the Constitution introduced a mandatory requirement to construe every piece of legislation in a manner that promotes the spirit, purport, and objects of the Bill of Rights. The purpose of statute plays an important role in establishing a context that clarifies the scope and intended effect of a law. The often quoted dissented judgment of Schreiner J.A. eloquently attributes the importance of context in statutory interpretation thus, and he went on to say that certainly no less important than oft-repeated statement that the words and expressions used in a statute must be interpreted in according to their ordinary meaning in the statement, and that they must be interpreted in light of their context. But it may be useful to stress 2 points in relation to the application of this principle. That first is the context, as here used, is not limited to the language of the rest of the statute regarding as throwing light of a dictionary kind or of the part to be interpreted. Often of more importance is the matter of the statute, its apparent scope and purpose, and within limits its background. We further cited the case in SBM and another versus the Attorney General. It's a Supreme Court decision that states that it's unassailable that the approach to interpreting fundamental rights and freedoms in the Bill of Rights by this court has to take the model of looking at the Constitution as a whole, which is purposive and generous, giving effect to the constitutional values, including substantive equality. In reaction to inequality and discrimination advanced by the petitioner in Prinsloo versus Vanda, this is a South African decision, where the court said it is convenient for descriptive purposes to refer to the differentiation presently under discussion as mere differentiation. I'll not quote the end of that ruling, but I'll go to the next broad issue. Under the broad issue of constitutionality, we identified the following points for determination. 1, whether there was adequate public participation. 2, whether the Affordable Housing Act violates Article 27 and 40 of the Constitution. 3, whether the Act infringes on Article 43 of the Constitution. 4, whether or not the Act amounts to a clawback on devolution. 5, whether the use of public land for development of affordable houses infringes on the functions of the National Land Commission. And 6, whether the Act is unconstitutional for failure by the CRA to consider the bill as per Article 205(1). On whether public participation was undertaken, the petitioner has argued that the enactment of the Act was not done in conformity with the various tenets of the Constitution, one of them being public participation. While they concede that some measure of public participation was conducted, it was their submission that it was not sufficient. It was therefore their case that at best what was done was a cosmetic exercise and a waste of public resources. The petitioner has argued that whatever was done by way of public participation went contrary to Articles 10, 118, and 201 of the Constitution. In particular, the petitioner has argued that the invitation notice to members of the public to present memoranda on the bill by the National Assembly within 7 days was too short, and thus the purpose of public participation cannot be said to have been achieved. Similarly, they contend that the deliberations of the Senate at the second and third reading stages was also constrained, with the result that it limited public participation to 7 days only, such that no public hearings could be conducted in any of the 47 counties. The petitioners also took issue with the fact that public participation was only conducted in 19 counties. They pointed out that 28 counties were excluded from the exercise in blatant violation of Article 10(1), 2A, and 27 of the Constitution. That the petitioners went further to state that the discrimination of the 28 counties and the refusal by the committee mandated with the conducting public participation or collecting views of the persons from the 28 counties was in blatant disregard of Article 47 of the Constitution of Kenya 2010, as read with Sections 4 and 5 of the Fair Administrative Act 2015, that require administrative action to be expeditious, efficient, reasonable, and procedurally fair. In addition, the petitioner submitted that although public participation was conducted in 19 counties, it was non-quantitative, non-qualitative, and therefore rendered meaningless. It was argued that public participation was conducted only in 19 counties, while the National Assembly executes its mandate in 290 constituencies. The petitioner has further argued that lack of proper public participation is evident from the reports of the National Assembly and the Senate. It was their case that the National Assembly and the Senate did not provide adequate opportunities for people's involvement in the legislative process of the Affordable Housing Act. In the same vein, the petitioner has also submitted that Kenyans had legitimate expectation that the Constitution would be followed in conducting public participation. In conclusion, the petitioner has urged this court to find that the Affordable Housing Act did not meet the constitutional parameters for public participation under Articles 10, 118, and 201 of the Constitution. Public participation is integral to the legislative enactment process. Under Article 10, 2A of the Constitution, public participation is one of the key national values and principles of governance. Article 118 of the Constitution provides as follows: Parliament shall A, conduct its business in an open manner, and its sittings and those of the committee shall be in public. Facilitate public participation and involvement in the legislative and other business of the Parliament and its committees. Failure to ensure public participation is fatal. Any action requiring it that proceeds without such involvement is invalid, as it violates an explicit constitutional mandate. This was the holding in the case for Doctors for Life versus the Speaker of the National Assembly and others. I think this is a South African decision that is widely cited. We are certain that public involvement was crucial prior to the enactment of the Affordable Housing Act. Public participation must be authentic, not just symbolic, and should not be treated as a mere formality to comply with constitutional obligations. It is important, therefore, that this court answers what defines proper and reasonable public participation as envisioned in the Constitution. We cite the decision in the South African case of Minister for Health and another versus the New Clicks, South Africa, where the South African court held that the principles of fairness are not to be applied by rote identically in every situation. It cannot be expected of the lawmaker that a personal hearing will be given to every individual who claims to be affected by the regulations that are being made. What is necessary is that the nature of the concerns of different sectors of the public should be communicated to the lawmaker and taken into account in formulating regulations. End of quote. Public participation does not necessarily mean that everyone must express their opinions. Instead, there should be tangible evidence of a purposeful initiative to incorporate a variety of perspectives in the participation program. This was as held in the case of Muiko Basin versus Moko Basin local community and 15 others versus the Permanent Secretary, Ministry of Energy. And we cite a quotation where the court said public participation does not dictate that everyone must give their views on an issue of environmental governance. To have such a standard would be to give a virtual veto power to each individual in the community to determine the collective affairs. The question that must be answered by this court is whether an opportunity was afforded to the public to air their views on the implementation of the Affordable Housing Act. This is as per the threshold set by the decision of the Supreme Court in the case of British America Tobacco, PLC, versus the Cabinet Secretary for Ministry of Health, Kenya Tobacco Alliance, and another, and Mastermind Tobacco, where the Supreme Court in this decision said that, and I quote, public participation has been entrenched in our Constitution as a national value and as a principle of governance under Article 10 of the Constitution and is binding on all state organs, state officers, public officers, and all persons whenever any of them A. applies or interprets the Constitution, B. enacts, applies or interprets any law, or C. makes or implements the public policy decisions. As aptly stated by the Appellate Court, public participation is anchored in the principle of the sovereignty of the people that permeates the Constitution, and in accordance with Article 1.4 of the Constitution is exercised both at national and county levels. The court went further to reiterate this principle in the case of Aura versus Cabinet Secretary, Minister of Health, and the National Assembly has argued that the invited members of the public to take part in the exercise which was conducted by the Joint Committee of the Department on Finance and National Planning and the Departmental Committee on Housing and Urban Planning, Public Works and Standing Committees on Roads, Transport and Housing, respectively. Both committees have demonstrated through their reports annexed as SN1 to the affidavit of Samuel Joroge, the clerk to the National Assembly, and JN1 to 3 of the Senate that support the assertions that the public and various stakeholders were invited and their views were taken into account before Affordable Housing Act was enacted. Herein below is a chronology as enumerated by the two affidavits that initial reading and committee referral that the Housing Bill number 75 was introduced to the National Assembly on the 7th of December 2023. The bill was subsequently referred to the Departmental Committee on Housing, Urban Planning, as well as the Departmental Committee on Finance and Planning. That on the 9th of December 2023, the Clerk of the National Assembly published a notice in the local newspapers inviting the public to submit memoranda. This notice was issued under Article 118 of the Constitution and Standing Order 127 of the National Assembly Standing Orders, which require the House committees considering bills to facilitate public participation. That the National Assembly reached out to key stakeholders, inviting them to participate in public hearings held across the 19 counties on various dates, and this was not the only form of public participation, as there was nationwide collection of memoranda and public meetings in chambers of both houses. That from the 9th to 16th of December, the National Assembly collected public memoranda, which was collected nationwide. During this period, Petition 103 of 2023, that's the appeal case, was filed, leading to an order from the High Court in Kisumu prohibiting public participation as prescribed by the published notice on the 9th December, pending the determination. Subsequently, the High Court in Kisumu temporarily halted the collection of public memoranda, but this did not stop the other forms of public participation which were ongoing. On 17th January 2024, the High Court clarified that its order applied only to collection of memoranda by the National Assembly. On the 29th of February, the High Court in Kisumu ruled that the notice issued by the Clerk of the National Assembly was valid and dismissing the petition. The court affirmed that the National Assembly had conducted public participation in a constitutionally compliant manner. This determination by a court of concurrent jurisdiction found that the National Assembly carried out public participation in accordance with the law. Based on the court's decision, it was concluded that the public participation, that is in the Kisumu case, had been properly conducted. We note that on the National Assembly extended its invitation to stakeholders through letters dated 11th, 13th, and 29th January 2024, requiring them to make oral presentations before the committee. These sessions were held on 29th and 30th of January 2024, as well as 6th and 7th of February 2024. We further note that the National Assembly that held consultations with various government agencies, including the State Department of Housing and the National Treasury and the State Law Office, offering opportunities for them to submit representations to the Joint Committee. This is to be found in the affidavit of Samuel Njoroge, Clerk of the National Assembly. The National Assembly then reviewed the written memoranda submitted by the public and invited stakeholders. A report detailing this consideration was annexed to the affidavit of the said Samuel Njoroge and marked as SN1. The bill underwent the second reading on 15th February. During that time, debate by members of the National Assembly took place, discussing the nature and effectiveness of public participation. The Assand report, which is annexed to the pleadings, details a report of the session of 15th February, which is attached to the pleadings here as SN2, and the documents this discussion. The bill was passed with amendments on 21st February and subsequently referred to the Senate in accordance with Article 110 of the Constitution. We also note that in line with Article 118 of 1B of the Constitution and Standing Order 145 of the Senate Roads, Transport and Housing Committee invited the public to submit written memoranda. This invitation was published in the Daily Nation, the Standard and the Star newspapers on the 23rd February 2024. These submissions were annexed to the pleadings and marked as JN1 to the Senate's response by an affidavit by Jeremiah Nyengenye, Clerk of the Senate. We note that the Senate conducted through its Committee of Transport, Housing, also sent invitation to key stakeholders to appear before the committee for public hearings on 1st March 2024. The invitations were marked and annexed to the Senate's response as JN2. The Senate Roads and Transport Housing Committee reviewed the memoranda and stakeholder submissions. After considering various proposals, the committee's recommended that the bill be adopted with the proposed amendments. These views were annexed to the Senate's response marked as JN3. On 12th March 2024, the Senate passed the bill with amendments. The bill was then transmitted to the President for assent, which took place on the 19th of March. It cannot be denied from the foregoing that the public participation was conducted. As shown, the National Assembly and the Senate focused on very targeted and specific stakeholders. In particular, the petitioners. We note that the petitioners took issue.
The fourth will be Honorable David Munyi Madenge. Fifth will be Peter Gichobi Kamoto. Sixth petitioner will be Grace Mondoni Mwangi. Clement Muchiri Muriuki will be the sixth. And the seventh will be Edwin Munene Kariuki. The respondents will appear as follows. First, to the fifth respondents, as they appear in E565 of 2024, that is the Speaker of the National Assembly as the first respondent, National Assembly of Kenya as the second, Speaker of the Senate will be the third, Senate of Kenya will be the fourth, and the Honorable AG will be the fifth. HE William Ruto, the President of the Republic of Kenya, will appear as the sixth respondent. And the interested parties, the first interested party will be LSK as first interested party. The second one will be Professor Kithure Kindiki as the second interested party. Unless there's a party which is left out.
Just a minute. Is there anybody who has been left out on the quorum to amend consolidated petitions? Yes.
And Company Advocates. I was left out in the morning in petition E013 of 2024. I had not been notified, and therefore I learned of these proceedings on the Nation TV, and I decided to come. So therefore, yes, I came all the way from Kirinyaga because Judge Richard Mwongo was very clear that we are going to be notified once the file is forwarded before the Chief Justice. There was no communication, so we were left stranded. What is happening? And our petition is being mentioned here today, and therefore we have had to rush very fast so that I can make it in a second session, that afternoon session. Therefore, I wish. Yes, maybe perhaps we can
Petition E13 and E14, Kagwea.
Yes, it was consolidated and we were told that we are going to be notified. However, we were not notified. I just learned of it today on the TV at 11. So we had to rush very fast from Kirugoya so that we can understand what is happening and perhaps clarification purposes.
Is there anybody who has been left out of
by law information?
Yes.
Just to draw to the court's attention, there is an application lodged on behalf of an interested party in the name of United Democratic Alliance, which can be considered at the appropriate stage. Thank you very much.
Intended interested party or interested party?
It's an intended. It has not been joined as yet.
On the parties?
Yes.
In this petition, I'm assuming it's one of those that you have mentioned.
You have not mentioned that petition.
Oh, okay.
And on that score, let me say this, that in the morning there were parties who had mentioned different petitions which were not before us. I think we should be very clear that we can only deal with matters which are before us. Should there arise a need for us to mention any matter which is not before us and which has been placed before us, we shall make that communication. So I think we need to be very clear that our jurisdiction is prescribed to particular files. Thank you very much.
My lords, your ladies, permit me to request that in is a petition, and E015, in which the Deputy President is a first interested party. Let the record of this honorable court show that we were not given an opportunity to be heard on the issue of consolidation. Let the record show the court has acted of its own volition when the normal practice, even under the Mutunga rules, is to accord parties to state their views on a proposed consolidation. This is the court's own violation. We were not asked to give our views. Thank you.
Your Lordship. Your Lordship, we have had the orders that have been granted by the court, consolidating the matters and creating another lead file. And that creates the problem you are trying to address in the morning, Your Lordships. That now this bench has created two lead files. We have which files are not before you. We have now created another lead file, E565. Your Lordship, those are some of the issues we were trying to raise in the morning. That if those other files were before you, this confusion would not be rising.
Mr. Legwa, there is absolutely no confusion matters. Let us not bring confusions where there's none. I think in terms of consolidation, we have cited the rule under which we have acted, Rule 17 for avoidance of doubt of the Mutunga rules. I think we need to move forward.
Yeah, and my lords, on behalf of the respondents, we confirm time has already been taken.
issues that are not of any substance. Save, we would like to make two proposals. First, we would like, my Lord, having read what has been filed by our colleagues this afternoon, we would like to propose that their application for recusal and this application questioning how the panel was put together should be had together for the very simple reason that they rely on the same set of arguments and facts. And I draw your attention to paragraph 5. They say that the impartiality of this court, the one we are before, has been questioned. And at the end of their prayers, they say that it is therefore in the interest of justice that this honorable court recuse itself. It would be gravely injurious to the respondents if they were allowed to prosecute this application, take one bite at attacking the court, and however the court rules, bring the other application for recusal and take a second bite. We would like to argue both of them together. Secondly, we would like an allocation of time, because it is quite clear to us that in the absence of directions allocating time, we are going to have another long afternoon of long-winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Professor Giffey,
Yes,
which applications have been filed? How many applications?
The one you directed, my Lord, in the morning.
Yes.
Yes. But it is in that application that has been filed by Jindo Matiba and company advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, requires the recusal of this bench.
So for avoidance of doubt, it is one application.
It is one application.
There are three applications.
But there is an earlier application for recusal. Yes. And that's why I'm saying we probably can hear both of them together.
Yes.
I'm sorry, my lord, but my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)b, justice shall not be delayed. So I'm requesting your lordships and my lady to kindly refer to that provisions and let us move forward. Thank you.
My Lord, let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my Lord, when Professor Gedhu Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the three presenting the one of that applications, is 1 hour. It is the least
that people deserve in an applications of this nature. Secondary issue, my lord, is the issues of consolidations. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusions, because we've had to include. Their earlier complaint in the morning.
I'm sorry to say this.
I have.
Candy, yes, I want to interject. If my learned friend is appealing against your orders, then there is the right forum. My lords and my lady, take charge.
There is no, I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We took the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my lord, if that applications were to succeed, then it would effectively remain, as my learned colleague Mr. Ngoya had indicated, that then the issue of recusal of your lordships becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners allege were committed by the Deputy Chief Justice are okay, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told different instructions. When we came here, we thought that while we were proceeding and taking directions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When we were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my lord, we cannot be able to argue, if it is today, we cannot be able to argue as expected by our client on the question of recusal. And there is no similarity of issues. Therefore, my lord, I urge you that let us adopt fair procedure. This fair procedure has always been there.
Specific application for recusal.
There are 2 applications.
Where are they?
We are not.
I know, therefore you mentioned one.
We are not.
We are actually bringing them even. One of them in number 050 is an application dated, I believe, yesterday, 21st of October. There is another one.
Okay, these are the directions we are making. We will deal with the application before us. The application for empanelment of this bench. Where's the application? Where's the application? Empanelment.
Yes.
Before you give the directions, with my line of friend is Kimoto. She's informing me that she was not aware of directions given that applications be filed and we come back before you. And now her petition has been integrated in the consolidated petition. That is petition number E013. Therefore, she's not been able to file an application either for recusal or for challenging the empanelment. She was just requesting if she can be served with those applications and the responses, and she given time, 1 hour just like the others, to file her similar application if she so wishes. because now she's participating in a proceeding. She did not direct us.
So listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in circle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll make a ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation,
we can't pretend that we don't know. And we know the role Secretary Syria has played in advancing jurisprudence, constitutionality, and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder at the bar and one who has seen quite a number of things which I may not be able to say if I'm representing the truth.
That is okay. We have done that.
Thank you very much. May I then comment on one small thing, Mike?
Yes, sir.
My lords, the country is in a crisis. There is a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so with tremendous respect, this is not a matter where you should be allocating some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 15 million of Kenyans. A number of them are glued now to radios and TVs trying to hear what is being said in this court. And for this honorable court to come and say that my ever friend, Mr. Mwite, will only have 10 minutes, will have no 5 minutes.
Mr. Mwite asked for 10 minutes and we allowed him to have 10 minutes.